award to the extent of patent illegality, which was not the ground for 34-1. For 34 ground, you got the fundamental policy of India, shocking the moral conscience, etc. Now, my lord, the point I'm making is this. Today, my lord, we need not go into what is the meaning of patent illegality, what is the meaning of fundamental policy. That is not the remit in my humble submission of this bench. I am putting, sorry, Lordship,
Please continue.
yes, Lordship, 34. But the point I'm making to Lordship is 34.
But 34 is an additional ground, not really a ground which permits.
Pardon?
34(2)(a)
Yes.
is an additional ground,
For domestic arbitrations.
but it does not permit segregation or division of an award per se.
Per se, yes. Therefore, your Lordship is right. What your Lordship is referring to 34(2)(a)(4), which
That
says
permits.
that, yes, maybe that's what your Lordship is. But my humble submission is, the point we are making, and I think there cannot be an argument against that the power to set aside will necessarily include the power to partially set aside. That's a well-settled principle in our constitution. The larger power will include the lesser power. You can't say either you set aside everything or don't set aside. To give a practical example, Manoj, we'll have to see the law as to how it applies in practice. Now, all of us who have done arbitrations at some time, it is, in a sense, something like a civil case where there is a claimant instead of a plaintiff, we call it a claimant. Then there is a counter. Issues are framed. Invariably, my experience is the issues are framed by the arbitrators. If there's a counter claim, they'll take it together and issues are framed. Now, the point I made last time, at the time when the bench rose, was take a hypothetical case where the arbitral tribunal frames, let us say, 7 issues. Based on the pleadings, they frame 7 issues. And out of 7 issues, let us further assume that 2 issues, if I may use the word, are infected with patent illegality. They are infected with patent illegality. Now your lordships have to decide. In such a case, do I set aside the whole award because it doesn't say partly, or the court can say these 2 issues are severable. They are severable. They are on a standalone basis. And I need not relegate the parties on all 7 issues back to the tribunal just because 2 issues are infected with patent illegality. Well, my humble submission is the word set aside can't be given such a rigid meaning as to make it inflexible and put it into a binary of a black or white. And once there is a patent illegality, the whole award goes. So my first request is, Lordship may see set aside must necessarily include partially set aside. That must be given, power must be given to the court, and I would submit it is inherent in the court. That inherent power is there. Lord, I'll show Lordship a passage from Ashok Hurra and Rupa Hurra in a different context on curative, where Justice Qadri says, we can't, once we see a patent injustice, we can't be a silent spectator and fold our hands and say we can't do anything. You can do. Now, my lord, on this partial setting aside, I don't think there can be much of a, in my humble submission, much of a problem, because if the court is faced with severability, then it can't be said that if it's 34(2), I will sever it, but if it is 34(2)A, I will not sever it. That will be an illogical answer. That if I'm a domestic award and I'm under 34(2), severability applies, but if under 34(2)A, a certain sense of rigidity comes in, that cannot be the answer. The larger, bigger problem on a day-to-day basis is this, Manoj.
But then you are going on the assumption
Yes.
that severability
Is there.
is possible.
Yes, that's my first limb. What I'm saying is, Lordship will imagine a chart, patent illegality, severable, non-severable. If it is severable, then to the extent of severability, partially set aside the award. That is the first submission. Now the larger problem now comes in. Suppose there is a patent illegality. Now first division is severable patent illegality, non-severable patent illegality. Now I am coming to the second classification, sub-classification. There is patent illegality and it is of two types. It's a curable patent illegality and a non-curable patent illegality. But in my final submission, I'll draw the chart and give it to you. But I wanted to make the chart after getting your Lordship's reactions and hearing the other side also. And I'll show with examples how this court, where the illegality is curable, they have not set it aside and sent it back. They have cured it here and now. So what do I mean by curable and non-curable? What I'm submitting is, if the patent illegality goes to the root of the matter, just imagine Lordship is now hearing an appeal from the High Court. Lordship finds the judgment has to be set aside. There is nothing else can be done but to set it aside. The judgment is so unsustainable that the court sets it aside. At the same time, a lot of times innumerably, Lordship has partly allowed the appeal. Partly allowed the appeal. So my submission is, if the patent illegality is curable, why can't we say that the inherent power of the court includes the power to cure that illegality alone? And now if a Lordship reads the section carefully, 34, I want to make a submission that only if is not confining the powers of the court, the only if is a maintainability. If you just read it with me 1 second and I'll go to my last part. 34.1 and 34.2, Lordship will kindly see. 34.1 says, recourse to an arbitral award may be made only by an application for setting aside such award in accordance with subsection 2 or subsection 3. So that means that the setting aside can only be on the basis of an application. Can't be a suo motu. Now, an award may be set aside by the court only if the party making the application establishes on the record. It's been substituted for proof. So my humble submission is, actually an arbitral award may be set aside by the court. There are two grounds. That only if must be linked only to clause A. Lordship will appreciate. It should be linked only to clause A, because unless the applicant brings it within 1, 2, 3, 4, 5, the application will not be maintainable. Now come to B. The court finds that. The court finds that. So typically what we do in real life, in day-to-day is, in our 34 application, if the award is suffering from an infirmity under 34(2)(b), we also add that as a ground, that the award is contrary to policy of India, or it's not capable of settlement under the law for the time being in force. That's not an arbitrable dispute. That we add it as a part of an application. But that is not necessary for the maintainability. What I'm submitting is, B indicates that there is an inherent power given to the court to address a case where the arbitral award is on a ground which is not capable of settlement. Suppose the party had not taken that ground at all. He satisfies 1, 2, 3, 4, 5. He doesn't take the ground that it is not capable of settlement. Like the Lordship has held, if it's complete fraud, forgery, it can't go for arbitration. He takes that point. Or it's in conflict with public policy. That ground is not taken. Can a Lordship say that, no, I'm bound by the pleadings? No. Lordship will say, look, I see the award. I see it's non-arbitrable. I see it's contrary to public policy of India. Therefore, I can interfere and set it aside. There my submission is in 34(2)(b). Also, it is not all or nothing. If there are 4 disputes, 2 are not arbitrable, those 2 can be set aside. If the remaining 3 are arbitrable, let it go, let it continue.
No, that's provided in clause 4 itself. So we
No, but
should
that, not in 2B.
not in 2B.
Yes.
Now, the difficulty, there are 2 ways to interpret, though it's not strictly within our domain.
Yes.
Or the reference.
Ah.
But if one looks at subsection 1,
Yes.
the recourse to the court against an arbitral award can be only made on an application for setting aside of the award in accordance with subsection 2.
Yes.
Now, this will mean an application by a aggrieved party.
Yes.
But if we look at B, the court finds that, so logically speaking, it says it will be only unless the party has taken recourse to an application in terms of subsection 1, the court finding will not be there.
Correct. The court can't see one award is come in the media, like I take under article 2.
Or even if, say, executing court cannot.
Your Lordship is right. At the order 21 stage also, he can't say, no, it's contrary to public policy, therefore I'm. Because by that time it become final and binding.
Correct.
Yes. So what I'm arguing is,
Sir,
sorry,
the court hearing at 34 is not a creature of this statute. It is a court which independently
it's a
exists
2E court.
with its inherent powers.
Yes.
Under the old act also, 151 has been invoked wherever statutory provisions were, found to be deficient. Probably Ramji Dayawala in
Yes.
context of 34.
Yes.
Additionally, 154 to stay the suit. So we will also ask them, would 151 CPC
Yes.
be available to the court, because we can't treat the court as a tribunal which is a creature of a statute.
Yes.
It is a court which exists with its inherent powers. Additionally, the power is conferred in this statute. Power is drawn from the statute in excess of its ordinary powers of a civil court.
Yes.
So, what stops a court from exercising 151 powers where interest of justice warrants?
But can your Lordship also see
Didn't provide in the old act.
Yes.
Scenario which would invoke 151 to stay.
Yes, and your Lordship is right, because definition of court is the court of the ordinary, the highest civil court in that district. So it could be the charter court, or it could be like in Bombay, Madras, Calcutta and Delhi, it is the high court. And in Bangalore, for example, we go to the district court. City civil court,
It's a principal judge of the citizen.
principal judge citizen. That's in Bangalore, Andhra, we all go to city civil. Nagpur won't go to high court.
The original site is only Bombay,
Only Bombay.
only for Mr. Kambad. Read arises from, say, Mulund, it will go before a single judge. And if it arises from Thana, just across the road, it will go to the division bench.
No, from what your Lordship is saying, if it's a Madurai bench, then again 34 won't lie. We'll have to go to city civil court.
Because it lies only to
Quite possible. Principal court of that
Principal
place,
court.
yes. So, my Lord, what in the light of what my Lord Justice Vishwanath asked, recourse to court, I mentioned yesterday on section 9 just before closing. Now,
So you can come to section 151 route.
151 route also, get the CP, 151 route also. Lordship will see 151, the same provision is also contained in rule 6, rule 9 of the Company Court rules. In the Companies Act, they say so. They say that the court will have all the powers to do justice. You take regulation 44 of the Income Tax Tribunal rules. Tribunal has all the powers to make in the interest of justice. Same thing in the CLB regulation. So what I'm saying is they confer it on a tribunal, but that need not be conferred on a court because a court has. Now the definition of court in 2 is 2(1)(e). Court means in the case of arbitration other than international commercial law, principal civil court of original jurisdiction in the district includes the high court in exercise of ordinary civil jurisdiction having jurisdiction. Now my submission is following following Dulabai's case, old Hidatullah judgment of Dulabai, unless the powers of the civil court are explicitly taken away, they will always continue.
implied that it will continue.
Pardon me?
It is implied that it will continue.
It will imply that it will continue. For example, the latest Companies Act, there is express provision that no civil court shall have jurisdiction to deal with matters of Companies Act. No civil court. Same thing, you take all the tax statute, no civil court shall. So the jurisdiction is ousted. So the law is basically jurisdiction is there, it has to be ousted. Here what they say is recourse to the court is there. So court has the power to grant relief. But that relief will be granted only on the basis of an application, as my Lord the Chief Justice mentioned. Absent application, you can't act. But once the matter is in court, he expressly says the court finds that. And then they further amend.
Even if their ground is not raised.
Pardon me?
Even if their ground is not raised, but if the court finds that
Yes,
it
yes.
suffers from the clause 1 and
Yes.
of B,
Yes.
the court will be empowered to exercise the jurisdiction.
Yes. No, this is not like the tax dispute. The question of law has not been raised, therefore I will not answer it. That is not the point. There also, my Lord, they say in 260A, the power of the court is like the power of a civil court. Lordship knows 260A subsection 5. Even if you don't raise that question, the court can still deal with it. That is so throughout the theme is that you maintain the powers of the civil court. So I'll just complete my submission by saying recourse to a court means recourse to a civil court. Keeping in mind section 9 read with section 151. The inherent powers of the court to do justice are always there, and therefore set aside must include partially set aside. Now I came to this issue, I'll come back to the issue of severability. Now in 34.
That's fine.
Therefore, my Lord, my submission is that the recourse to the court under section in the 34, there is an implicit power of the court. To what extent it is taken away is limited by 34(1)(2) and 34(4). What are the limits to which the court cannot go? They are set out in the explanation. Kindly come to 34, explanation 1. Please come to explanation 2 of 34(2). For the avoidance of doubt, the test as to whether there is a contravention of the fundamental policy of India shall not entail a review on the merits of the dispute. So this is like a red line which says that, not at the heart of the day, they say don't make it a section 96. Don't convert it into an appeal. And my Lord, perhaps the best discussion is that Lala Bansidhar's case from Delhi High Court it came. What are the types of jurisdiction? There is an appellate jurisdiction, there is a revisional jurisdiction, and there is a reference jurisdiction in the old income tax cases where the High Court's jurisdiction is only on a question of law. The tribunal continues to be incessant of the matter. The High Court decides the question of law, and then the assessment order is passed in the lines of the High Court order or the Supreme Court order. So your appellate jurisdiction, revisional jurisdiction, reference jurisdiction, and this is another kind of a jurisdiction called application jurisdiction, where there is a new type of jurisdiction I'll give the Lala Bansidar's case. Very detailed discussion on what are the types of jurisdiction the High Court had. Let's get Lala Bansidar. So there's an appellate, reference, revisional, and now it's an application where the power is limited. And what are the limits? One explanation is you can't do a review of the merits of the dispute. So as the Lordship put it, you can't go get into the merits, you can't step into the shoes of the court. Lordship will note section 107 of the CPC says the power of the appellate court is as much as the power of the civil court. Under section 107 of the CPC, the appeal court can do everything which the
Coextensive.
open court,
Coextensive.
coextensive. This is not a 107 power because this is not an appellate court. So Parliament says fundamental policy, don't go to the review of the merits. Now please see proviso. Provided that an award shall not be set aside merely on the ground of application of law or by appreciation of evidence. And it's erroneous application of the law, not a complete error of law itself. you apply the law erroneously. It is like the old Anismini case. Jurisdiction. You can err within the jurisdiction. But suppose you apply the law completely wrongly, then your lordship said it is perverse, irrational, and so on. So my submission is, section 34 has inherent, it is not taken away explicitly. The word is may be set aside, and the two explanations give a yardstick as to what can be done. Now please come to 34.4 also, where also there is an indication. Now 34.4 came bodily from the international commercial arbitration. Obviously, my lord, if the award is passed in ICC Paris or another country, and it comes for enforcement to India, then what happens? In an international award, you're not an appellate court, you're not a court 2E court. Yes, Taylor versus Taylor, thing done in a, yes, Lordship was right. Taylor, Singapore. Technical documents have not been considered.